Everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Say, how can I express?
How can I express my gratitude
For all the many things,
all the many things you've done for me?
words are not enough.
Words are not
Yeah.
enough to say thank you.
Say, Lord, you are my everything.
You're
One
my
more time.
everything.
How can I express my
How
gratitude
can I express my gratitude
for all the many things,
all the many things you've
Father,
done
you
for
done for
me?
me? Yeah.
Words are not enough to say thank you.
Say, Lord, you are,
Lord,
you
you're
are.
my everything.
Say, I call you Zion.
call you Zion. Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
Lord, you're my everything.
I call you Jireh.
Call you Jireh. Lord, my provider.
I call you Nisi.
Nisi.
You are my banner.
My banner.
I call you Rapha.
Call you Rapha. You are my healer.
Say, Lord, you are.
Hello, good afternoon to you, wherever you are. This is BWTV on a Saturday afternoon, bringing you the community and the law, doing that under the auspices of BWF Solicitors, our trusted partners when it comes to the law. My name is Oreku Frimpong, and today I want us to be concentrating on children and young adults. And what we're going to do is to look at how we can rise from nowhere to the highest point we can be. How your child qualifies for British citizenship, indefinite leave, or long or short limited leave. These are going to be picked one after the other, and we're discussing. Our guest is Mr. Bernardo Usu, the senior partner of BWF Solicitors. Uncle Ben, we call him. Ladies and gentlemen, brothers and sisters, tell the other person that we are live on BWTV, on BWF Solicitors Facebook, YouTube, and all the social media platform. Let's get into it together.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernardo Usu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernardo Usu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured. assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
And you're welcome back. This is The Community and the Law, brought to you by BWF Solicitors, both here in the UK and in Ghana. BWF Solicitors, 0208 493 7340, or in Ghana, 00233 55 589 5959. And in emergency situations, call 0044 7712 761884. You can find the numbers at the bottom of your screen. Now, it is another Saturday, and we're so glad and delighted to be coming your way for another edition of The Community and the Law, the program that brings you very lively and up-to-date discussion on issues surrounding the law here in the UK, especially when it comes to immigration matters. But the other issues that you have that you would want to throw at the lawyers, and they will be glad to give you answers. Look at BWF Solicitors at the Anna House on the 4th floor, 214 to 218 Tottenham High Road, Seven Sisters, North London, N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. So when it comes to immigration matters, advice on how to invest in properties here in the UK and outside of the UK, especially in Ghana. When it comes to family law, marriage, divorce, and what you can do with those situations when you do get into those. And then again, when there are any updates from the Secretary of State from the Home Service, then definitely you would have that coming from BWF Solicitors the very first time. So thank you for joining us. We're live on BWTV, live on Facebook at BWF Solicitors, live on YouTube at BWF Solicitors, and all the social media platforms. Now, people do this, so I want you to be part of that wonderful, exciting experience. They pick up the link and share. And at the end of the year, definitely, you know that you may be rewarded. The senior partner would appreciate you. So go onto the comment section of your Facebook page and YouTube page, like the page, share the link, and definitely click on the notification button so that when we come your way with any content, you will be notified firsthand. BWF Solicitors, we thank you for your support. Now let's see who is with us on the line. And before I even introduce my guest, let me say thank you to Tiliduma. You on board? Please kindly share, comment, like, and share that. Okay, Louisa Santi, hello, Uncle Ben Brakwe, cool and precious family, and pink waving. Okay, yeah, you're waving as it's written down there for you. Adem Nunkum is on another great topic from BWF Solicitors here. Definitely, it is one great topic we're going to look at. Sandra Fraser, good afternoon, fellow viewers. Share when you join. That's the gig. Okay, so let's keep going. So those of you who have joined us, let's feel you. Please share. That's from Nana Ajima, the class prefect. Lyrical Black, I am here some. Yes, we too we are here, and we're happy you are with us. Then we have Sajida Emmanuel. Amen. God bless you and your family. God bless you too, Sajida. Now with this done, let me go over to the other desk next to me and to the realms of BWF Solicitors to introduce our guest and resource person this afternoon. In fact, I shouldn't even call him our guest. He is our patron, and was because we are at their mercy. Let me put it that way, because they graciously support us all throughout. The senior partner, Mr. Bernardo Usu, is here with us, and this afternoon he's going to lead us into the discussion how your child qualifies for British citizenship, indefinite leave, or long or short stay here in the UK. It's also good afternoon.
Good afternoon.
Thank you very much for joining us, and we're so happy that when we're able to pull you out of your busy schedule, you graciously do that, and you always do that with a smile. We're happy. Thank you for coming.
I thank you for having me.
How is the family?
Well, everyone is doing fine. As fine as we can be.
Right.
But by the grace of God, we are all well, and I hope yours is doing well
Yeah,
as well.
yeah, we're doing very well. And the exciting thing is when it comes to Saturday afternoon, you would want to rush and come and meet the community, and especially when we have you coming, then it's extra bonus. Well, viewers, we are going to have a discussion with Mr. Benadozu, as I mentioned earlier on. So get ready for that. BWF Solicitors does so many wonderful things, especially when it comes to updating us in the community. Now, this week, from the beginning, we had the nugget that was thrown at us, and it's the Section 17 of the Children Act of 1989. And it says that this act imposes a general duty on local authorities to safeguard and promote the welfare of children in need in their area. This includes providing accommodation and financial subsistence to families with children in need, even if they have no recourse to public funds. Now, this is from the case R. Limbuela versus the Secretary of State for the Home Department, the 2005 case, a UK High Court ruling 66. So, what is this talking about? It's about something here. We'll get Uncle Ben to talk about, but it's talking about children and how the local area will definitely have to support such children. So first of all, let me find out what this act is saying and how it applies to it and why it was even dropped on us earlier this week. Uncle Ben.
Okay, so Kweku, we usually do a broad spectrum of topics, and there's a thematic area. As you can see, we dealt with the increase in the fee waiver, where IHS, Immigration Health Surcharge, the potential increase again in qualifying for spouse under the maintenance rule. And this obviously comes in for those people who maybe haven't made an application yet, or have made an application, a decision has not been made, or have made an application, a decision has been made, and they've been restricted from having access to public funds. So this broad outlook of law, it's available to parents and their children. It's not only for the children, it's for any adult who's providing care or guardianship to the child. And it imposes a duty on the local authority, which will be the area where the child normally lives, to provide them with accommodation and support. And the child must be a child in need for them to qualify. Usually, the assessment will be broadly around what we call destitution. In Ghana, when we say destitution, people talk about people, mad people who are sleeping on the road. It's not only mad people, but also it's people who do not have accommodation. And or maybe have accommodation but don't have the means to support themselves. So this duty is there.
Right. So when the assessment is made, what I would want to find out is there a minimum threshold that a young person may have to meet before they qualify for the Section 70 provision?
Okay, so every child must have what we called a free avenue to potential growth to the best of their ability, be free from disease and sickness and anything that impedes that, which may be in unsuitable accommodation, lack of funds to support them, possibly living in the most deplorable situation because the parents cannot afford a better place. This will be a child in need. So any child whose potential development is affected by the circumstance in which they find themselves will qualify for a child in need. And at the very minimum, the local authority has a duty to perform an assessment. And once they perform an assessment, they will then have to decide how they meet the duty. It's not every person who will qualify, but it will be a child in need. The definition of a child in need is potentially a child whose growth, development, either learning ability, health, access to accommodation and food is unavailable or restricted, then there will be a child in need.
How does such a child get to the local authority? Does it have to be reported by a concerned person? Does it have to be reported by the parent, or maybe for public purposes, the police?
Well, so I treated this topic on Thursday, and I gave three organizations that you can go through. The first one is Project 17. Project 17, as you know, Section 17. So their main dedication is to support parents who are going through destitution and children whose are children in need, and they are a charity who main remit is to support parents to make an application under Section 17 of the Children Act of 1989, and they have a broad experience in this area. There's another one called Section 20, but that's not what we're talking about. So they will support you. In fact, when you call them today, and they will do a telephone assessment, and if they find that you've got a child in need, they will support you today.
Okay.
They will immediately send you money, find an accommodation for you, and then deal with the local authority and recoup their money from them. But the reason why I ask people to go through them, or Hackney Legal Center, or their Youth Legal, I shared the telephone numbers on Thursday. I haven't readily got it. But if you go online and you say Project 17, it will give you the telephone numbers. The reason why I prefer that people go through this instead of approaching the council directly is that the council are stretched, their budget is stretched, as you know. You work with the council as a senior officer, so you will know this. In my borough, for example, my local authority now have sent notices around. They intend to collect our rubbish every other week. So once every 2 weeks, although they do it on a weekly basis, they collect the brown and the blue different weeks. So because somebody's gone to gamble with 500 million of our money and they've lost that money. So there are many boroughs in the councils, local authorities who are either bankrupt or on the verge of bankruptcy. So they haven't got the money. When they find that you potentially a parent, barely able to speak English, can't string two sentences together, even in pidgin English, you approach them. They scare you off. They threaten you with taking your child away, putting your child in care. They threaten you with reporting you to the Home Office, or they will threaten you with making sure that you're sent back to your country. So don't go to them. Go to Project 17. Project 17, we know that they support people because we've referred people to them whom they've supported. Sometimes Deborah even makes calls herself, and then through that they support them. So for us, the preference is to go through one of these organizations, Project 17, Hackney Legal Center, and then Youth Legal.
Okay. Well, the advice is given. Go through them. Let the authorities know through them, and definitely they will support you. As the nugget says, every child is to be given support. The Section 17 of the Children's Act of 1989 imposes a general duty on local authorities to safeguard and promote the welfare of children in need in their area. This includes providing accommodation and financial subsistence to families with children in need, even if they have no recourse to public funds. So when you are in destitution, don't sit down, put your hands in your bosom. There's help. Approach the right organizations and you'll be supported. Now, the second update that came in the community and want to quickly look at is a married partner. What is the definition of a married partner? Now, there's a new and updated definition, and it started on the 31st of January 2024. Now, it says that the Home Office has now amended the definition of a married partner, removing the requirement to have been living together for 2 years to where the couple have been in a relationship similar to marriage or civil partnership for at least 2 years. There's a difference here. A married partner, Do you have to have lived together for 2 years? Do you have to have been in the relationship similar to one that somebody would describe as a marriage or civil partners for 2 years? That would qualify for that broad definition that the Home Office is giving. This update says that there is no longer, can we go back to it? There's no longer a requirement to have lived together for 2 years. That's an update. Maybe you would be hearing this for the very first time, or you have been confused about it all the while. Akaben is here. So I'll throw it to him again and ask, why the new definition from the old one?
Well, I think Kweku, what the Home Office does is that they look at trends, and the trend basically is not every settled or durable relationship where the parties live together. You will find parties who don't live together, have children together, but have an enduring relationship. By enduring relationship, I mean a relationship which is long lasting and deep,
Okay.
and weighty. So relationships like that, although they don't live together, relationship is akin. And when we use the word akin, A-K-I-N, it is similar to marriage. It's a settled relationship.
Okay.
The census that we had recently clearly shows that many families, potentially over 30%, are living in the UK with unmarried partners or have relationships with unmarried partners, and many children are born out of this relationship. So I think it's a reflection of where our community is.
Okay.
And therefore, the requirement to have lived together is taken away. But again, there are other definitions of partner. Before, when we look at immigration rules, paragraph 6.12, it defines unmarried partner as somebody you've lived with in a relationship akin to marriage for 2 years. That aspect of living together is what has been taken away.
Okay.
But enduring relationship, the intention to permanently be in a relationship, the requirement to have met the person, the requirement that is a genuine and subsistent is still there. But it's beautiful, because if somebody lives here and say they've got a partner in Ghana and they want to bring that partner, usually the requirement of having lived together for 2 years had always been a hindrance or a stumbling block, and therefore they are not able to bring their partners to the UK because they cannot show that they've lived together. Now that requirement is not there, but they still have to show evidence of contact, discussions, relationship, meeting, and plans going forward, and that the relationship is an enduring, deep, and qualitative relationship.
Well, so the definition has been amended starting from the 31st of January 2024, is that the Home Office says that they have removed the requirement to have been living together for 2 years to where the couple have been in a relationship similar to marriage or civil partnership for at least 2 years. And Uncle Ben used that expression akin to. So wherever you meet that, or whenever you hear that, it's talking about a relationship that's similar to the one that could be called marriage or civil partnership for at least 2 years. So there's no longer a requirement to have lived together for 2 years. Now, these updates will keep coming, and that will be brought to you by BWF Solicitors. And when we come on the community and the law, we'll reiterate them and get the further and particular details of that for you to have a good understanding of what the Home Office would have brought in the week. Well, with this out of the way, I would want to also encourage you to keep the nuggets in mind, because later on I'll be going to my quick segment where I'll be asking you about a situation and see if you can really apply the nugget and the knowledge we have shared to the situation and give me the correct answer. So the quick segment will be coming later on at the tail end of the program. 0 to hero or she hero. How your child qualifies for British citizenship, indefinite leave, or long or short limited leave is up for discussion next after these messages.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Yes, welcome back and thank you for sticking around. It's still on the community and the law live on BWTV under the auspices of BWF Solicitors and again brought to you by BWF Solicitors. This afternoon we're looking at the steps and the ways you could get to apply for a British citizenship and how your child qualifies for that. So from nothing to the very top. That's why we say zero to hero or she hero, how your child qualifies for British citizenship, indefinite leave, or long or short limited leave. The text number, whilst the discussion is going on, that you can send your questions to 07399 208 468, 07399 208 468. You can send a WhatsApp or a voice note to 07950 422 780, 07950 422 780. Now, we're going to have our discussion based around several themes, and we would be picking them one after the other to get you to understand what we're talking about. We will be looking at children born in the UK who may qualify for indefinite leave on their first application. We will be looking at if we can ask for 30 months or 60 months for the child on the same application fee but with 5 years IHS. We'll look at the reasonable test and case of SSHD and AB Jamaica. That's a very popular case that helps us to understand what we are talking about. Then we will look at how can children with EU pre-settlement status get into this situation as well. Then young adults. I mentioned earlier on in my introduction that we'll be looking at children and young adults. Young adults and the route to settlement. Who is a young adult? What age range or bracket are we looking at? These are things that would help us understand the topic we've put out. So come with me and let's go over to the desk of Uncle Ben to find out British citizenship, the qualification criteria. How do we do that, Uncle Ben?
First of all, when you're applying for British citizenship for a child, it means that a child is not a British citizen from birth or
Right.
automatically.
Okay.
And that's why you're applying. Sometimes application is made purely on discretion. Other times is made based on entitlement. So we need to separate the two.
Okay.
Our focus now is application made purely on under discretion. Now, when a child or if a child is born in the UK to parents who do not have status. The child doesn't have any status as well. And obviously, if the child's parents acquire status and obtain settlement, the child can register anytime after that. Or if the child lives here for 10 years, then the child can. Or if someone comes to the UK, wasn't born in the UK, but came to join parents and the person is still a child, and the case guidance notes clearly says that where the person has been here for at least 2 years, and then in the circumstance of the case, the child should be given British citizenship, and or one of the parents is British or is applying for British citizenship, then a discretion will be exercised in the child's favor, and the child will be granted British citizenship. And then there are those who have lived here for 10 years. And again, under the law, the route to go is that they spend their first 10 years here. So even if they spend the first 10 years and left the UK for 20 years and came back when they are 30 years, you can still register. And that's a right. That's not a privilege. So these are things that we need to consider.
Okay.
Now, when I say that it's a discretionary application, it means that even if you don't qualify, you can still make a case for it. Last week, I did emphasize on under Section 6.1 of the British Nationality Act for adults, that when you're making your application and the residential requirement comes, which is 450 days over the 5-year period, if you spend up to 900 days, you can make a case for discretion to be exercised. In the same way, if the child hasn't been here for 2 years, but has, at the time of application, has unlimited leave, so indefinite leave to remain, and the parents are also settled, then the child can make a case. There's a case that I made. The child was playing football for Barnet, playing for England, under 16 at the time, and we made a case that, to enable the child to travel around Europe and potentially the world, the preference is to have a British citizenship, and they gave it to us. There's another case where we made where the parents had settlement. The child also had settlement, but the child had 2 younger siblings who were both British citizens. And this child always questioned the parents that, Daddy, why is it that my passport is black and my brother's are, those days, it was a burgundy color, or what we call a red color. And that reason we explained that was causing some sort of emotional turmoil in the child's life, and we were able to get a school letter to explain that the child has been in school for all this duration, although the child obviously wouldn't have one of the ingredients which the parent is applying, or one of the parents is British. They were successful, and they gave it to them. So when it says discretionary, it's very good. When it says,
then it gives you room to make out your argument.
That's
and
correct.
Ask for it.
That's correct. So those are the things that we look for when we're reading or interpreting a rule. Usually, will be the immigration rule, and then we look at what is mandatory, what is non-mandatory, and what is discretionary. And even when we start the next options, we will go through and we see which other areas that falls within the 3 broad outlines that I've given.
So you said that children born in the UK may qualify for indefinite leave on their first application. You have introduced the word may. So it means that if the child is born in the UK, they don't automatically qualify for British citizenship. Is that correct?
Okay. So now the topic says, or the synopsis says, that a child who is born in the UK may qualify for indefinite leave to remain. That's different from British citizenship. So the child is not British. It tells you the parents are not British and haven't got settlement, because else the child would have been settled or had British citizenship. But on their first application, they can get indefinite leave to remain. What it does is that it cuts out all sorts of unnecessary stuff. And even before he turns 10, he can then apply for British citizenship. And it's the same way that I've explained. Why? Why? Because in 2021, we know that there was a concession for young adults, for children and young adults, to switch from the 10-year route to the 5-year route on private life. We also know that in 2022, the laws were compressed into one, and paragraph 276 ADE, paragraph 276 BE1, BE2, BE3, paragraph 276 BE, and they were all compressed into what we now call the PL, or the Private Life Annex PL. The Annex PL then covers all the areas that Appendix FM doesn't cover. So that when we talk about Appendix FM, we used to have parent root, partner root, children. So parent root, partner root, and children. And then we had a paragraph 276 ADE, paragraph 276 BE. This covered young children, 7-year root, and then young adults, people who have lived here half of their age and are under 25 but above 18. So that's why we call them young adults.
Okay.
Now, the Home Office has compressed all that into one law. So the concession has been pulled into the law, but I will explain as we go along. It's a very complex area, and we need to break them down, and that's what we'll be doing this afternoon.
So, I'm still on the first application.
Yes.
What should children be applying for on their first application? I'm asking that you say you may apply for indefinite leave. If an application is made for a child, so if the parent has 2.5 years, is it what the child should automatically apply for?
Okay, so when we look at Appendix PL 1.1 to 1.2, it talks about the eligibility rules. We look at the suitability rules for children under 18. If the child was born here and the child has lived here for 7 years, those days, what you remember is the 7-year rule.
Yeah.
What did the 7-year rule give you? It gave you 2.5 years.
Yeah.
But now it gives you indefinitely. That is a change.
Okay.
So the change is that a child who was born here has lived here for 7 years. There's a continuity of residence, and I'll explain that. Very technical words. The child qualifies for indefinite leave straight away. I've also said that a child can apply for British citizenship by way of discretion, and that is the discretionary route. And if the child has no limit on their immigration, they can jump from indefinite leave to British citizenship. But the focus now is the word may, because the qualification is not only time, it's not only 7 years, it is not only born here. It's also that it will be unreasonable to expect a child to leave the UK. And that is why I brought in the case of AB Jamaica, which clearly defines what an unreasonable circumstance will be. Usually the Home Office default position is that a child who's born in the UK and has lived in the UK for at least 7 years, it will be unreasonable to remove the child. So already there's a default position, but you need to show why it will be unreasonable for the child to leave the UK. And that's why I use the word may. So instead of just telling people that you can make an application when your child has been here for 7 years, sorry, your child was born and has lived here for 7 years, and they get indefinite leave, you need to explain that it's not just that, but there are other circumstances that you need to meet. One is a threshold of the unreasonability of the process of the removal. And the Home Office own guidance notes, clearly the latest one is January 2024, says that a child who was born and has lived here for 7 years, the default position is that it will be unreasonable for the child to leave the UK. So that is one aspect. Also, if the child came from outside and has lived here for 7 years, and the child is under 18 years, the child can apply, but they will get 2.5 years.
Oh, okay.
Under the 10-year
Under
route.
the 10-year route. Okay.
Now, let's then go back. There's also, as part of the synopsis, that they have the short route and the long route. So they can give them 5 years straight away, or they will give them 2.5 years.
And renewed at the end of the 2.5.
And then renew at the end of the 2.5 years. What does it do? It saves you money, because the application fee is 1,053. If you're doing that on 2 occasions with a delay and a lawyer's fee, obviously it's going to cost you a couple of thousands more. So again, that is a focus that we want parents to know, that if you brought your child to the UK and the child hasn't got any status, you haven't got any status, or you've got status, but the child wants to apply under Appendix PL or private life. The child, when they make the application, they can elect to be given 5 years instead of 2.5
from
years.
the onset.
And it's their choice. The difference is that they pay the same immigration fee, but they pay 5 years immigration health surcharge. Just bear in mind that children pay about 30% less than adults pay. So adults IHS for a year is 1,035. For a child is just 600 and something pounds. It used to be 435. So that would be times 5. So the Home Office guidance says that when they make the application, they should write to tell them that, do you know that you qualify to be given 5 years, instead of 2.5 years? And if you want us to give you the 5 years, please top up your IHS, but application fee is the same.
Okay, so it means that if you elect to apply for the 60 months or the 5 years, you will pay your IHS for the 5 years, but it saves you the application fee if you apply for 2.5 and go to renew and pay another application.
That's right. And also, we know that for children, if they live there for 5 years, they get indefinite leave. And the Home Office has been specific. Last week, KK called. He obviously was speaking on someone's behalf. The person has been here on the parents' route, have relied on the parents, the family life with the parents. Now, when you read the law carefully, Home Office is telling their caseworkers that be careful. Don't treat a child as part of the parent's application. Segregate it and treat the child under private rule. And they've given scenarios what you have to do. The reason why that is so, and KK raised it, but I think what he got wrong was that he thinks his daughter or whoever he was speaking for must only be here on a private route before they can qualify for indefinite leave. No, that's not the case. And the guidance clearly states that that's not the case. You can mix and match. And even they make reference to the old style 276 ADE or BE. They also make reference to the old style where the child was considered as part of the parents' application. They said children in that category, when they apply, they also qualify for the 30 months or the 60 months. So you can see that they are very, very careful, because I think they want to shepherd all the children on the private life route. There's also another aspect that we will look at. That is those who are young adults or above young adults, having been here for 20 years. But then they also can apply for status, and it's not as straightforward as it is. So usually I'm very careful when I'm advising on that. When you tell people that you can get residence if you haven't been here for 20 years, you're actually raising their hopes, and sometimes it causes all sorts of problems. The threshold is very, very high. Right. There are 3 case laws. A case law of Mahmoud, for example, Shahar. Those are cases where they've looked at what we call the high threshold of obstacle to integration. And we'll look at that when we come to the other issues here.
Well, you mentioned a reasonable test. And there's this popular case that lawyers you referred to, AB Jamaica. Reasonable test. Reasonableness on whose part? Is it the caseworker, or the person making the application would have to put out reasonable reasons, if there's any expression like that, to be reasonable and considerate in what the person is asking for? What are we looking at?
Okay, so the reasonable test is an objective test. And when people say objective test, it's fact specific. Okay. So each case is different. Somebody may be here 18 years and they will not qualify. Somebody may be here for 5 years and they will qualify. The reason why, when it comes to whether it will be reasonable to remove or refuse an application, is to determine whether the current circumstance of the person now, the current circumstance, warrants the application being granted, because it's not fair on the person to be removed from the UK. The case of AB Jamaica, widely used, interprets the reasonable test as an objective test that looks at the current circumstance of the person, not where they want to be, but of the person now, and apply that to what is likely to happen. So real life situation is not procrastination or forecasting, but it's to say that if we remove you now, these are the set of circumstances that you will face, and those circumstances are such that it will be unreasonable for you to be removed. Bear in mind, and I put emphasis on it, the Home Office starting position is that if a child has lived here for 7 years, it will be unreasonable to remove the child. The default position is for the child to stay here.
Now, circumstances that people may get into, do they give us some examples as to what the expectation would be?
Okay, so for example, if a parent is going to be removed, you can't leave the child alone here, although the child may qualify in their own right. Those are one of the circumstances, but the parent can also turn around and say, my child qualifies under the law, because when you look at the case law, if the child meets the law, then automatically it will be unreasonable to remove the child. So the parent can turn around. But that is one circumstance. The other circumstance is that the child came here, maybe they are still under 18, but they've spent their formative years outside the UK. And they always make references to the formative years. That because you lived in the UK and your parents because you lived in your country of birth throughout your formative years, and your parents are they are being deported. Therefore, it will be right for you to go with them. And although the default position is not to remove, in this case, it's not unreasonable to expect the child to be living his life in his immediate family, and therefore the removal of the family will go together.
Okay. And then, having looked at these things and all that, I'm tempted to ask the question again: how do children qualify for British citizenship?
Okay, so first of all, there is the automatic qualification under Section 1.
Mm-hmm.
There is the application under Section 3.
Okay.
1. And then there's the application under Section 1.3. 1.3 is a child 10 years. So if the child was born in the UK, has lived here for the first part of the 10 years, then they can bring themselves within Section 1.3.
Okay. There
are children who are also born to military people serving in the Her Majesty military service. Those children, because their parents are not subject to immigration control, there's no time limit on their residence, they qualify for British citizenship.
Okay.
And then there are children whose parents are not married, and because they acquired citizenship through the father's side, and the parents were not married, the child was deemed to be an illegitimate child because the parents were not married. Those children can also come under application, what we call application UKF, which is a UK father. So that would be under Section 4 of the British Nationality Act. Then there are children who have come from outside the UK. These children have been here. There's no time limit on their residence. Their parents are not British, but yet there's a discretionary route for them to go through, for them to justify to the Secretary of State that because of who I am, I've lived here. I came here when I was 5. I'm now, let's say, 14. So I've lived here for 9 years. We've all got indefinite leave now, but I want to get British citizenship because of A, B, C, D, discretionary. That is also a possibility. And then there are children who are born outside the country to parents who are British citizens otherwise than by descent. Okay. So if you're British otherwise than by descent, all it means is that you acquired your British citizenship by way of registration or naturalization. And then you can pass your citizenship to your child automatically. But there are also children who are born to people who are British citizens by descent. That one, the right to pass on the citizenship only goes the first generation, and it cuts off. So if, for example, Kweku, your child is born in the UK, the child acquires British citizen. The child acquired the citizenship through you because when he was born, you are British. The child acquires a citizenship by descent. Mm-hmm. When he gives birth to a child in Ghana, that child gets British citizenship otherwise by descent.
Okay.
Then that person cannot pass the
Person,
citizenship on
because I understand.
outside the UK unless their children come and give birth here. Those children can also sometimes register as British citizens if they go and register at the nearest British consulate
outside of the UK.
outside of the UK, because that is deemed as part of the United Kingdom jurisdiction. So there is option to register there, and then they will also give you the citizenship. So broadly, there are those who qualify straight away automatically, and there are those who have to be registered as British citizen, and some who go through by right, others who go through by discretion.
Okay.
Yeah.
Now, in all these discussions, do we factor in the EU people with pre-settlement and all that? Do they come under this, or is just under British immigration rules?
Yes. So the EU people will come in. So obviously, if somebody's got settled status because of their grandmother or their grandfather who's an EU national, or their father is married to an EU national, so they've also got indefinite leave. Of course, they can register as British citizens because there's no time limit on their stay here. Although the law says that a child, whilst a child, if they apply for British citizenship and the Secretary of State deems it right to give the child a British citizen, the Secretary of State will give them British. That is the qualification.
Okay.
So there's everything I've said is not in the law.
Okay.
Everything I've said is the guidance. The guidance by the case of Pankina has the weight of something similar to law, but it's not law, which means that the guidance cannot take away your right, but it can give you a right. So what I've said is simple. It says a child, whilst a child, if they apply for British citizenship, and in the eyes of, I'm paraphrasing, the eyes of the Secretary of State, he feels that a child should be given British citizenship, he will give the child a British. That is all they need to show. But when you go to the guidelines, it says at the minimum you should have lived here for at least 2 years. At the time you're applying, there should be no time limit on you, and maybe one of your parents may be applying or are British citizen. But those ones are not law, and that's why I say the discretion is there, so it's open. And I gave you 2 examples of one who was playing football for Barnet Football Club, and another who had 2 other siblings, and they were using the Burgundy passport. He was using Ghana passport. And every time they had to go through, and then, he said, Daddy, why am I using this passport? So those are the discretionary routes, which is open for everyone.
Okay.
Open for everyone.
Well, if you just joined us, we're having a discussion on how your child qualifies for British citizenship, indefinite leave, or long or short limited leave. The senior partner of BWF Solicitors, Uncle Ben, is here and taking us through all the technical bits. I can feel that somebody, Uncle Ben, that's for these things. Listen, the advice I'll give you is the conditions are there, the updates have been given, the clarifications have been given, and he is on live on the set doing that. If you need anything to get to understand, I know somebody's trying to reach us on the line, we haven't gotten there yet. If you have to understand anything and you're confused about it, don't worry too much. Just contact BWF Solicitors on 0208 493 7340, 0208 493 7340, or emergency number 077 127 61884, 077 127 61884. Dawa Jima, you're watching with us. Thank you very much. Collins Drakes, you're watching with us. Nanetu Ahine, yes, I've seen your text messages and questions. We'll be picking them up later on. And I want to advise everyone watching that if you have a question or concern, you can text that to the studio number 07399 208468. Send a WhatsApp or audio note to 07950422780. Or you can leave your comments in this comment section on Facebook and YouTube, BWF Solicitors. Remember, it's BWF Solicitors. Or you go to BWTV, both on Facebook and YouTube. Lee Wilson, thank you very much. Jeff Holland, you are here. Raps Hasford, thank you. Rick Marston, thank you for watching. Clayton Woodslam, thank you. Eric Boachi and Eric Boateng. Samuel Tesfu, Laura Cobbs, we have Josh Barnett, Robert Jemfi, Dennis Bales, Matthias Dongele is watching, Naomi Favor Pokia, you are here with us, thank you. Kwame Kobi, you're also here, thank you very much. Marcy, Elliot Bloor, Phil June Turner, you're here. Samson J. Kudia, Mame Inda Bozo, DJ Mickey Lupo, Daniela Moa, yes, I mentioned you already, thank you. Stuart Taylor, Linda Sante, Pastor Ima Favor. There's this one that just came on. Kenneth Ofori Boateng, good day, family. Antobam, thank you very much. Kosi Koram, thank you for watching with us. And Rama Kwache, also you're watching. Thank you. Abraham Shaba, thank you for watching. Leave your comments on the comment section. Like the page, share, and let's get so many people liking the page and also joining us. And I want to have as many shares as possible this week. Who is leading in the sharing challenge? Is it you? If not, share more and you stand a chance of winning that wonderful prize at the end of the year. BWF solicitors, thank you very much. We'll take their message and when we come back, I'll be asking about how EU children also fall into this whole conversation. Is there a reverse benefit that people can get from this whole situation? We're talking about adults conferring their rights on the children having their own roots to their rights as British citizens. But question is, can there be a reverse benefit as well? Then we'll also be looking at the young adults that I mentioned earlier on and how they can also benefit from this situation. We discuss it. Then again, there may be other routes or a combination of routes. I've heard it done before. I will be looking at that as well from the senior partner, BWF Solicitors. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Well, thank you very much for joining us. I just received a message, and I think the person wants to share that joy with us. And I want to say, well, Uncle Ben, that's to you. The two pieces of good news this week, and both are being shared with you and to your credit as well because people appreciate you. Our family in Sheffield is giving birth to a baby girl, and was born on Wednesday. Now, one of our loyal listeners and clients, Atajima, just sent a message that just this afternoon his wife's giving birth to a set of twins.
Oh,
And wants
that's
me to tell
beautiful.
you.
Oh, that's beautiful.
that was what came in. I was looking at it and the camera came back on me.
Yeah.
So the
Congratulations
BWF
to
family
both
is
of them.
growing.
Yes.
Yeah.
Yes.
He says I should tell you. So
Oh, beautiful.
and to you, congratulations. I know why. I now know why you spend so much time in Ghana. Thank you very much, Atajima, and congratulations as well. Ahmed, well, we're back. We're looking at this very important topic, and before we went on the break, I was looking at the EU settlement scheme, people that fall under that. I mentioned the reverse benefit. Now, if a child has that conferred on him or her, can that also have that reverse benefit to another parent?
You mean if the child gets a British citizenship?
Yes.
Oh, yes, yes. So if you've got a child who's got a British citizenship, it's one of those grounds that allow you to, you as a parent, to make an application under family life as a parent to stay. So yes, that also helps the parent's route.
Okay.
Because a set of conditions, British citizenship is the highest, and
That's
then indefinite leave, 7 years, and in certain circumstances, children who have limited leave to remain under the EU requirements here.
right. We mentioned young adults. By definition, who's a young adult?
So, by the Home Office definition under Appendix PL, a young adult is someone between the ages of 18 and 25.
Okay.
So, they have a different set of circumstances which they can follow, the route which they can follow to acquire residence in the UK. And when you look at Appendix PL, so we look at those circumstances. For example, Appendix PL 10, I think to those areas, for example, if somebody has lived here for half of their life, then the person can apply for residency.
Okay.
And they can either go the long route or the short route. The long route is basically doing the 2 or 2 years, 2.5, 2.5, or they can do the 5 and then do the indefinite. Now, when you look at the settlement guidance for private life, it says that even if the person at the time they are applying for settlement are over the age of 25, but they've spent the 5 years in the UK lawfully, under the grounds, they will be given indefinite leave to remain. And again, I did explain that a child and a young adult can ask for the 60-month instead of the 30-month, and that will save them at a minimum £1,053.
Right.
Yeah.
Now, the routes that you've mentioned, is one expected to follow one strictly from the start to the end, or you can start, navigate your way, get to the middle, look at a route that may be cheaper, shorter, and more convenient, and you will switch to that. Or we could combine several routes, getting to the same destination.
Okay, so we know that the longest route is 10 years.
Yes.
We know that for young people and young adults, they have shortened that. They said it's in the interest of children. For someone who has had his adult years in the UK, it is reasonable to bring them in line with other visas because spouses are on 5-year route. So that's why they've created that route for them. And as I said, it's now under the PL. What they have said, and KK raised it, when you read the law, if you're not careful, you might think it's only private life route that takes you to settlement. No, it's not. They say by any combination. So you can combine and go to the 5 years. However, they've now advised the caseworkers that when you're looking at an application, make sure that you're considering the child under private life.
Okay.
Because in that way, their route to settlement, because it's defined, is quicker. 5 years instead of 10 years. Because parents can make application. They may have a child here who at the time is 2 years, 3 years, 4 years. They've got a British child. So the parent is dependent on a British child. This child who's been here for 2 or 3, who was born here but has only been here for 2 or 3 years, is not British, hasn't got status. He doesn't qualify under the private life route, but he's dependent on his parent under the family life. But the child, when he turns 7, he can apply for indefinite leave. So you don't punish such a child and say because you've been on your parents' family life route, you cannot come and apply for settlement under the private life route. The advice sometimes is at least they've spent 1 year under the private life route. But that same line also says that a combination of family life and private life will suffice. So the reading is that in certain circumstances, you may be required to show some private life.
Mhm.
And that's why the Home Office have given instructions to their caseworkers. Always segregate the child. So the advice they've given them, if a child, let's say 14 years, apply with a mother, they are dependent on their British brother.
Mhm.
The 14-year-old has been here for 7 years, but they are dependent on their British brother. The mother has made the application. They've put, all of them have come on the family life forms. The Home Office instruction is to remove that child who is 14, who has lived here for seven years,
7 years.
and consider him under private life.
Is that giving prominence
Yes.
over the others?
Yes. Yes, because he will have a shorter period to indefinitely than his mom.
Okay.
His mom is going through the 10-year route.
Yeah.
If you don't do that, the kids will be going through the 10-year route.
Unnecessarily stretching.
Absolutely. So the Home Office has told their caseworkers, in that case, remove him. Not only remove him, but also let him know that instead of the 2.5 they've applied, you can give him
Up to
5
6.
years. So write to him and say, pay this, and we'll give him 14 days. If you don't hear from him for 14 days, assume that he doesn't want to. And then you give him 2.5 years under private life.
Okay.
And therefore, this, if you look at the guidance notes for private life for adults, young adults and children, is very, very strict for caseworkers.
Well, I have asked the questions, but I believe that you may have yours, and there are others. There's a very, the very first one I'm going to look at is this one that says that, but in the meantime, you can send in yours by text or WhatsApp. Text is 0739920848, and WhatsApp is 0795042270. We have this on our WhatsApp platform. I have a daughter who has pre-settled status under EUSS derived from her grandmother. Grandmother is EU national with settled status. My child's biological mother was refused settled status because she moved from her mother's house to rent her own property. So no proof for defendants. 3 times refusal. But the child has 5 years pre-settled and holds Ghana passport, not EU passport. Mother has no status now, so how can the father use direct access to apply for 2.5 years leave? Father has family life with child, emergency contacts at school, GP, physiotherapy, contact order from court, and the like. Child is 9 years, UK born. Laura, can the father apply for FLRFP? Is this a pure human rights application? What is the probability of that application becoming successful?
I wish I could play a voicemail, a voice note to you, but you know, sometimes you're not careful, people will identify the voice.
Okay.
I'm not sure why people don't know that this exists. Even lawyers don't know that it exists. I may have to share this with Adai. Maybe he will show us, but we'll do that subsequently because he has to go through the technical bit. When you look at Appendix FM, you look at E, eligibility, family life of a parent, and you look at 1.3, I think D, I'll correct myself when I refresh my memory. It says that the relationship qualification, child under 18, child British, or has EU pre-settled status in accordance with GEN 1.3. Simple. Now, so if you've got a child who lives in the UK and the grandmother is the grandmother is an EU national, the first thing I would do is to get either settled status for the child or pre-settled status. Because the child is a grandmother's family member. There's confusion. We've got a big fight with the Home Office, and I know they will lose. I've taken my time to deal with it. They quote a law which is non-existent in Appendix EU. And they're using that to refuse children whose parents are married to EU nationals for their settlement. I will come to that later. So if your child in this scenario, Adai, show that again. What this person is saying is that their child is in the UK with a pre-settled status under EUSS, which is derived from their grandmother because they are family members. The grandmother is an EU national, absolutely, with settled status. So the child should get settled status. The British Home Office is making a mistake. Your child really should get settled status. Whether they have settled status or they have pre-settled status. When you look at the law is very, very clear. And I mentioned paragraph eligibility leave to remain 2.2, and the relevant section is C. And it says either British citizen or a child with an EU pre-settled status. And this is a parent application. So if your child has EU pre-settled status, you can rely on the child.
Okay.
If your child has EU settled status, you can rely on the child. In this case, the mother has been refused several times because there's no dependency. Mother has no status now. 3 times refusal, but the child has 5 years. But the mother can depend on the child. Our law, the immigration law, is very complex. I know that people feel that you can just do chin and chika on the way, and it's a try and error, and then if it works in your favor, it works in your favor. So I will share my screen with Adai. He will put it on, and then we will all see. Because for us, what we need to do is to educate the community.
Right.
And education is pointing out what will help them. The law doesn't help you if it only sits in my head. And the only time you get to assess it is when you come to pay me money. No. So what we do is that we explain the law to you, we empower you, we explain and say that in this case, you can rely on this law. And the law that Adai will show, if we get to show it, because we have to go through the technical bit, it's the Home Office own guidance notes. So if you look at the eligibility leave to remain parent, so it's section ELTRPT. Once you see PT is parent.
Parent, okay.
So the parent is applying for limited leave to remain, right? Let's look at 2.2C. So for the parent to qualify, they have to show a relationship. Let's go to A and start from, so we call it elimination by substitution. So when you look at A, it tells you the child has to be under 18 years. Right? And that since the applicant was first granted entry clearance or leave to remain as a parent, must not have formed an independent family unit or be leading an independent life. The child must be doing what?
Living in the UK.
And
a British citizen settled in the UK or in the UK with limited leave under Appendix EU in accordance with paragraph Gen 1.3D or has lived in the UK continuously for at least 7 years, immediately preceding the date of application, and paragraph EX1 applies.
So when we look at C, what does it say again?
A British citizen settled in the UK or in the UK with limited leave under Appendix EU in accordance with paragraph Gen 1.3D.
Now, you see that C and D are alternatives. There's a reason why. So the child is in the UK, it didn't say with indefinite leave. Because where they said indefinite leave, they use the word settled.
Settled, right.
So when you look at C, there are 3 conditions which are all alternatives.
Yeah, because of the word or in there.
Because of the comma, not even the or.
Oh, wow.
So in law, where you see comma, it means that it's an alternative.
Okay.
To the
preceding or the preceding one.
That's correct. So, one, the child should be living in the UK. And where they want to use in addition to, they use the word and, must be 1, a British citizen. 2, or a settled person in the UK. 3, or in the UK with limited leave under Appendix EU in accordance with paragraph GEN 1.3D. Or, so where they want to use the alternatives, they use or and they use comma.
Okay.
Semicolon has a different interpretation under the Interpretation Act. So these are things that, as a lawyer, these are the tools at your fingertips. So in this case, the lady who's had all these refusals can say that they want to rely on their child because the child is either British, has indefinite leave, or has what? Pre-settled
status, yeah.
Yes.
Okay.
Those are the requirements. And therefore, my advice to her is that she can use this law to make an application, in addition to Article 8 and family life, and also supported with Appendix EX1, because the child is here. There might be compassionate and exceptional circumstances.
Okay. We've got a voice note on the phone. If you want to send us a voice note, you do that on WhatsApp 07950422780. So we can pick that one up.
Afternoon, Uncle Ben, Rakwaku. Uncle Ben, Rakwaku, and lovely viewers. Me pacho me pese me bisa asam kakra. So then Uncle Ben church mono. Me pese me who say wa pofro no e wa ha say na na they say graduate 2.5 na man sa. At the end of the day, you've spent a lot of money already. That's a lot of money. So I wanted to find out, because my application, I said 1 year, and we 10 years already, but we still went ahead because like the family were doing it all together. Emma, even your 10 years, I need these 10 years already, and Sana decision and then again with the 11 I'm person who say the Siano, do we have to apply for indefinite for her? And I say obey to me I apply for British passport no. And again no, what are the necessary documents obeying here and with me at the year as application and my second child is so 8 years no also no or 2.5 already. I am we and I'm person maybe say on so waiting me I go ahead I apply for indefinite straight and I say British passport because honestly we live they have all lived here throughout this years now. Thank you very much. God bless you.
God bless you too. Well, when I think this is a conundrum somebody has. They didn't know and they waited till the 10 years, and the second child is 8. So the question is, can they apply for indefinite or British passport? I think the question is trying to, can we register them now as it is?
Well, the child is 8, so the child qualifies for indefinite leave because the child was born here, has lived here for 7 years.
Yeah.
So the child qualifies for indefinite leave. Now, this is why we like to bring the solutions. This parent doesn't know. She's going to pay money, and now the child, even 10 years, the 2.5 years, she will be 11, she thinks, before she applies for another indefinite and then a British. So the child, every child who's born here, if they live here for 7 years, they get indefinite leave. If you apply for it, it's not automatic. If they live here for the first 10 years, if you apply for it, they get a British citizenship. So that's for children who are born here. If a child was not born here, but let's assume it's that a child is from the age of 2, they've been renewing. The child is now 8. That child, if the child was born here, will get indefinite leave straight away. Yes, the fee is about 2,000 plus, but it's better than paying IHS and then paying home office fee. It comes to the same thing. But when you add either the 60 months or the 30 months money to the 1,053, it will give you about the same amount, if not more. So you're better off applying for indefinite leave. And that is why we like to be practical and bring this very nuanced positions to our community. And, hopefully if there is time, we'll go on to those people that can apply if they haven't been here for 20 years. Usually will be adults, not young adults, but adults. But usually will be adults who have not been here for half of the years, have not been here for 20 years. And we will look at that as well. But she's gone through this already before hearing from us. But if she wants to wait, she can wait and naturalize, register the child 2 more years to go. She wants to apply for indefinite if she can. You can always let the Home Office know if they haven't made a decision in an application that you want to switch the application.
Oh, okay.
Yeah,
Okay.
you want to switch, and they will switch you.
Right. You mentioned that people who have lived here in the UK and haven't attained the 20 years and all that. There's a question that somebody's put. I don't know. We might come to that. Let me pick the call, and we'll come to that so that we'll have the opportunity of getting that answered, because I think it's going around. People think that you can, some say you cannot, and all that. 0208-493-7345. Hello? Hello, good afternoon.
Hello, good afternoon.
Yeah, thank you for joining. Yes, how are you doing, sir?
I'm fine. Good afternoon, Ben.
Good afternoon.
Kwaku, you're looking so smart this afternoon.
Oh my gosh. Thank you very much.
Kofi Atubamonda.
Oh, Kenneth. I should have known because you put it on the platform already. Thank you very much. Thank you so much. Yeah.
Question is, with these applications, actually, this question goes to you anyway.
Thank you.
With this children application of these 7 years, let's say when you apply, if the children are with the mom and they're renewing for the 2.5 years, if you just renew for the 2.5 years, is it going to be automatically given to the children alone indefinite, or you have to ask or request for? That is my first question. And I'm just wondering if you can help me out with this concerning Ghana Embassy. I don't know if it's part of this program, but I just wanted to bring it. They brought something of like a premium for our passports. I've tried this premium, and the premium is taking about 21 days. Is that a premium actually? Because the money that I paid for is unbelievable. And then, so if there's something we have to know, which Ghana Embassy have not told us, we don't know, because they've added a premium service to their services. But when I applied for the premium to be renewed, I thought it's going to be like within a short time. But that one is about 21 days. And the cost for it is unbelievable. You pay some online, and when you are at the embassy, the office itself, you have to pay for more services. I don't know if anybody else come to this. Thank you, and I'll put it down and listen to you.
Okay. I think for the second part, I would have to take it up and find answers from the Ghana High Commission, and the Premium Application Center, I think, is located around Tower Bridge. We will pick that one up and get an answer for you, because I don't think Uncle Ben may know. I don't think so. But let's go to your first question, the children application.
Well, I mean, there's nothing automatic about anything. So if it's automatic, they will let us know. Usually for things that you pay, there's nothing automatic. What the guidance note says, that the caseworkers should proactively encourage people or let people know that either they qualify for settlement or they qualify for a longer temporary leave, which is 5 years, or if they don't answer, then they give them the shorter temporary leave, which is 2.5 or 30 months. The emphasis is on proactivity and evidential flexibility. Because when you read the guidance notes, they've put a lot of emphasis on evidential flexibility. And when we say evidential flexibility, it's the Home Office taking an active step and letting you know that there's a missing evidence in the documents that you've presented. And if there's an evidential flexibility in the guidance notes, it means that it can be enforced in court. And therefore, if the Home Office doesn't follow their own guidance rules, then it becomes a problem. In Kenneth's case, the child will have to apply for indefinite leave. Now, let me emphasize again, the route to settlement are children born in UK, have lived here for 7 years, they get indefinite leave. The other route to settlement is that a young adult, whether born or lived in the UK from outside and lived here when the person was a child, but now it's a young adult between the ages of 18 and 25. The person can qualify for 60 months, which is 5 years, and then after that they get indefinite leave. Or if they are not, they don't follow up, or they don't ask, and the Home Office writes to them and they don't follow up, then they will have to be given 2.5 years on the 5-year route to settlement. You can combine private life and family life in this route. The guidance note says that. And when you read the law itself, PL 1.2, 1.1, 1.2, and you read PL 2.2, there are certain things that you have to look at. There are those mandatory, non-mandatory, and then discretionary. 1.2, 1.1 to 1.2, 2.2, and then 4.1 to 4.5. Those are the discretionary grounds, again, that you can rely on. But our emphasis today is to let you know that if your child was born here and they've lived here for 7 years, they qualify for indefinite leave to remain straight away. We will talk about the young adults who are in limbo. They are not under 18. They are between 18 and 25, or above 25, and they haven't done 20 years. We will talk about that later.
Well, thank you very much. There was this question, as I said, we're going to go on to. Somebody's asking, I'm an adult, I've lived here for less than 20 years. Can I apply for indefinite leave to remain?
Well, if the person has lived here for less than 20 years, there are provision in the rules, but I'm going to state what the rule says. Mm-hmm. The rule says that if somebody has lived here for less than 20 years and they can show, please let's pay attention, and they can show that there are significant obstacles. So obstacles is already a problem. Now the qualification is significant, and there are case laws. We'll come to that later. So if you tell someone that someone comes to you and say, "Oh, I've lived here for 18 years," and there's a case law, the case of Shah, where the person has lived here for 18 years, and you can apply for 20 years. Yes, the law says that you can, but there are certain tests that you have to meet. One of the tests, and the most important test, is that there are significant obstacles to your integration in the country to which you are going.
Okay.
So if I can show that I've lived here for, let's say, 15 years, mm-hmm. I'm 35 years. Yes, I am 35 years. You all can see that I'm 35 years. And I came to UK. I came to UK when I was 20. I've now lived here for 15 years, and I want to apply for indefinite leave. I've heard that I can apply for indefinite leave even if I haven't been here for 20 years. And that's true. But there's a test for you to meet. And the test is that there are significant obstacles to your integration in the country to which you are going to live in.
Okay. And that's quite an arduous one to prove.
The guidance knows that it's a very high threshold. There are case laws which we will look at. We'll look at a case of Catherine Lau, for example, a Jamaican case. She was here for 15 years. There's a case of Parvin.
Mm-hmm.
Parvin, Indian national who had lived in Indian or Pakistani national who had lived in the UK for 18 years. He failed in the test of significant obstacles to your integration in the country to which you are going to live in. And it's broadly questions that we will have to answer. So the test is high. So when you come to us, we will assess you. Sometimes I don't like to say these things because when you say, people misconstrue them. For example, one of the examples Home Office has given in their guidance notes is that if you are gay, okay, and you cannot go to that country because you will be punished, and you've lived here, let's say, a significant period of time, but you haven't lived here for 20 years, you can use the gay to show that there are significant obstacles to your integration. It's cultural, it can be language barrier, it can be sickness, it can be civil strife. And Home Office is giving examples of the reasons people give. They say all those reasons are bogus. I don't have anybody there. But they say, well, when you came here, you also didn't have anybody here. But you were able to stay.
Well, yeah.
I've lost my friends. Well, it doesn't matter. It will be difficult for me to find way. But the same reasons the Home Office are saying are bogus, you can use the same reason if cumulatively they create a significant obstacle to your integration. Is it easy? No, it's not easy. There are people who may qualify. So if you have a medical condition, and we know Article 3 is high threshold. Article 8, medical ground, they always want to push you to Article 3. So you can apply and say, I've been here for 12 years. I am 26 and I've been here for 12 years, or I'm 28. I've been here for 12 years. I have this significant medical condition which will make or create a significant obstacle to my integration in the country that you want to send me. And these are all evidence-based. And therefore, Kweku is very significant here.
Okay. 0208493735. Hello?
Oh, hello.
Yes, good afternoon.
Oh, hello. Good afternoon. Sorry, let me know.
Yeah,
hello,
thank you very much for doing that. Yes.
Yeah, good afternoon.
Yes, please go ahead.
Yeah, my name is KK.
Oh, okay, KK.
Yes.
KK, if Uncle Ben was writing a book for today's program, he would have been quoted 3 times.
And also a big thank you. We thank Uncle Ben for educating us on this complex area of the law and clarifying things for us. Right now, my question is, in view of the education is given us today, and it's the clarity that is given us in view of this law. Now, I think I can ask my question again because last week I believe we did not, or probably Uncle Ben did not understand my question very well. That's what I believe. So I'll put my question across again. Okay.
Yeah, go ahead.
Okay. Now my question is, for the purpose of this question, let's concentrate on a young adult, okay, who meets half of his life test. I think we've got that right. Okay. Now, if that child or that young adult has been in the UK for 5 years legally, now all his previous application, his decision letter says, let's say, for example, leave, or his leave has been granted under Appendix FM, or as dependent, or as family life, or even under discretionary leave. Okay, and he served 5 years under that, and these were granted pre June 2022. Okay. Now we are in post 2022. He now wants to make an application. Now I've checked the letter, and it was granted. The decision letters, okay, says all of what I've just mentioned. Now my question is, now he's in a dilemma. Now, do we have to write? Also, Uncle Ben did mention that the caseworkers are encouraged when they make such an application as a family year, they need to separate the young adult who qualify to be granted leave under his private life. On this occasion, it's clearly not been done. So now that we face with this problem, what I was asking was, do we have to write a letter to the caseworker to say that, oh, hang on, we ought to have done this, and he did not do it? Can you amend the letter, the decision letter, okay, that says the leave was granted or has been granted, the previous leave has been granted under private life. And once we receive that, then we can take advantage, or we can put an application to and take advantage of the early settlement, the 5-year early settlement, which is in place now. Or do we have to make another application again, and then we ought to be granted under the private life? And then once we receive it, we can straight away put an application through for the settlement. However, should we do that one? It's too expensive, absolutely expensive. Uncle Ben, how do we go about this?
Okay,
Please.
KK, don't go away. First of all, how old is this person?
How old is this person?
Yes.
Yeah, he's 22.
So this is a young adult. And this person has stayed on family life for how many years?
5 years.
And when was the 5 years?
When was the 5 years?
Yeah.
Yes.
Like the 5 years end, it will end, I think, in 2 weeks' time.
And has this person applied for indefinite leave?
No. We are not going to apply for the indefinite. We are not going to apply. Right. He was granted under 10 years, so he's done 5 years on that private life.
Okay.
Now, because of post 2022, okay, we want to take advantage of the early settlement.
Mm-hmm.
But all his letter says, leave us at the
Yeah.
So I don't know. I'm confused.
But KK, I sent you the guidance notes, which says
Yes.
a combination of any route. I've just looked at the law. I don't like reading whilst I'm on air because people I like to flow. Else I would have given you the specific here. Now, you raised an earlier point that because I said there's a discretionary, if they apply with their family, they should switch them to private route, and they haven't done. At the time you're asking for someone, I know. At the time that person's process came through, if the 2.5 is going to be up in a couple of months, it means that this was before the law change, right?
Yes.
I will broadly go with the application. I will say that I'm making this application in line with Appendix PL on the basis that as a young adult, I have spent 5 years lawfully in the UK, although under Appendix FM, private family life. I'm making this application for indefinite leave because of the intention behind the early grant. And then when you go to the guidance notes and you go to the immigration rules and you go to the explanatory statement, you will see in the explanatory statement, the guidance notes, that they want to shorten the process leading to settlement for young adults who have spent significant time of their childhood in the UK. So is the intention. Now, as I told you, the Home Office has a lot of discretion around this. And therefore, although the rule says that at least 1 year should have been spent on a private life basis, you are saying that even if the application that granted them family life had been made now, she would have been separated from the family and would have been put on the private route. In the circumstances, it is not against public policy for her to be given indefinite leave to remain in the light of the explanatory statement, the guidance notes, and the intention behind the policy. If you go with this, nice English, nice quotation,
yes,
but you have to also go beyond and explain that there will be it will be unreasonable to expect her to leave the UK. You quote Article 8 in support of that, but your reliance is on what we call the explanatory statement. Every immigration rules, and this one is Immigration HC, I think is 4111. That is what brought all this together. That will help you to write a detailed letter and explain that the intention, the explanatory statement, the guidance note says that you want to bring all adults, young adults, in line with the current process of granting people indefinite leave after 5 years. She hasn't been a criminal in 5 years. She hasn't overstayed here. She's been here lawfully for 5 years. The only thing that you believe stops her is because it was granted under family life and not private. KK, you don't have a problem. I've told you already last weekend that you don't have a problem. If you want me to do it for you, bring it. You know, we'll come and do we'll do a small margin. Come and do it. We'll do it for you. I'm happy to do it for you.
Okay, thank you very much.
Yes, Mr. Koran.
Thank you.
Okay, bye-bye.
Yes, KK, thank you very much. Kenneth says, KK, I always like your contribution. Thank you so very much, Ka. You bring out a lot more for people. Thank you. Hi, my child is eligible for ILR, indefinite leave to remain this year, as ISA is due this year. This year will be completing 5 years. She's 5-year-old. Nupur, your question is...
I understand what you're saying.
Okay.
So
it's good I have them in mind.
Nepal is saying that her child will qualify for indefinite leave. This is similar to KK's situation.
Okay.
But she has been on it for 5 years. You see, she's not worried. She's gone straight. My child qualifies. But right. KK, it's, you know, KK reminds me of somebody I know. They always like to look at all the options, which is very good. So yes, I'll put the question again, Adai. So she wants to know whether this year we will be completing 5 years. She's 15. So she's not quite a young adult, but she will qualify for indefinite leave.
Okay.
So I will advise you to apply. I assume that she came here when at the very least when she was 10. Or it may be that she came here when she was younger. Yes, you can. And you quote the same laws that they've used to justify why they are giving young adults and children a short route to settlement. There's every policy, every law has a policy. And when you look at every law, Home Office does what we call impact assessment.
Okay.
The impact assessment will come either before or after. But in this case, what will help anybody who's making this application where their children have been on family route instead of private life route is to quote back to them the intention that they gave in the explanatory statement.
Okay. Well, 0208493735. I've got a voice note here. We'll quickly deal with that. Pick another comment from the comment section and we go to do our quiz. Okay, well, let's take this one. Oops. Well, let's pick a comment there. We'll sort this one out. Yes. Children 16 years, 13 years, and 11 years who entered UK with indefinite leave to enter. When can each of them apply for British citizenship? The dependent parent has indefinite leave to remain.
Yeah, we've dealt with this. So, as I said, under paragraph 3.1 of the British nationality, the only requirement is that a child was a child if an application is made on their behalf for British citizenship. And in the eyes of the Secretary of State, he deems it fit to grant the citizenship. They will grant it. That is all. But when you go to the guidance notes, there are other issues that they raise there. Now, if I'm arguing as a lawyer, I will say that your guidance note seems to be adding extra burden to this requirement. The requirement says that 1, the person must be a child. 2, an application must have been made for the child. 3, in the eyes of the Secretary of State, if he deems it proper, he will grant this. But you've gone to put in your guidance, the person should have been here for at least 2 years. The person's parent, one of the parents must be British or not. This is an extra requirement. It's not in the rules. So, Secretary of State, I'm a child. I'm making this application. I have no criminal conviction. My character is okay because I'm above 10 years. Nothing wrong with me. I meet the residential requirement. I meet all the other requirements. Please give me British citizenship. And I'm sure that will be okay. So they all can apply now if they want to.
Okay.
Yeah.
Hello, Braco. Good afternoon. Uncle Ben, good afternoon. The most legend of Paya, Bob, or mine. About your question, Kakra. Eddie can back to Mrs. Tabacco, my gun and or a German. Number two, Papa, any indefinite 2022 November. Na Omobano so June 2020, which me say, Onya, I own us and only indifferent. I can't call for British book. And I can't, Papa indefinite December 2022. No, indefinite ma Corano. But I only passport to be a as no my can passport a mano. Because Papa no at 12 fear on the mamma no current time, but Munya Ariano. And I can't German passport. Telling a mamma person could register Aquano as a British citizen because Aquano indefinite will know 1 year or so. Mamma dear or the Sukra preset to now. Union indefinite will be a September. To be just so register her application online, a document of submitting. Normally, I can submitting online, but Omoka so far upon a passport has in the EU ID card and la own your original. How I lend the moon trim and a bed set in the Bibia or Tim Busam said no, and once him to acquire a bit money a British book and I proceed and to say. Secondly, but to rules now saying, oh, by seeing and say, oh, but saying this open every part. Who can't do that on your van for 10 years and send on your passport to know or your British passport and that's all. And as they say, no more about 5 years, say ultra 5 years and that's 1 year, not your passport, which is 6 years and no one but that's
Well, this person and a child born prior to the parent having an indefinite leave to remain, the marriage, they kind of separated. The man is out of the home.
Yeah.
What is the situation of the child as
well? So we tend to have this situation always, and where the relationship is broken down, it appears that the other parent doesn't want to support the child's British citizenship. So what happens is that they usually will then have to make or to take extra steps to ensure that the child can prove that the other parent now has indefinite leave and therefore they can apply for British citizenship. What happens is getting the evidence. What happens is getting the evidence of the other parent's settlement. The Home Office has a duty sometimes towards children all the time to disclose certain information if the court asks or if another agency asks. So my starting point is question. How did you know that the father has indefinite leave or the husband has indefinite leave? How did you know? That is my first question. If you have the evidence, the EU card is not necessary. The evidence will normally be in the form of an email or online. If you're doing your check and prove, right to work, it will show that this EU person has indefinite leave. That will suffice.
That will suffice, yeah.
The nationality people, they like to pretend that they are not part of the Home Office. So when you make your application, you always must quote stuff because the High Court of Appeal have said that when you make your application and you don't make certain demands, and then you later come to court for judicial review and say that, oh, you didn't follow this, but you also didn't make that demand. Then you cannot say their behavior is unreasonable. So you also need to put in the request when you make your application. We know this man, so and so, Nana Usu, born 1975 in Bekwai. He came here, he's got a German passport, he got his indefinite leave, we think, around 2022. This is a stepchild, and therefore we are also making an application for the child to get indefinite leave or to get a British citizenship because it's the father. At the time parents were married, so that would be the father. And that should be okay. So I think they can do it or they can get legal advice.
Well, I look at the clock and I'm like, wow. I am running out of time, but
Wow.
let me just stress that your questions,
Somebody sent the text.
your questions, your concerns are still being piled up, and we will be looking at them in subsequent times. But if you have any concerns with the law and other things, call BWF solicitors and speak to one of the lawyers. Let me get you some numbers here that will be of benefit to you. You can call Uncle Ben himself on 07712761884, 07712761884. We have Lawyer Charles, 07947 63 60 37, 07947 63 60 37. Lawyer Eunice, 07535813910, or send an email to admin@bwfsolicitors.com. Admin@bwfsolicitors.com. Take advantage of the numbers they've given out and speak to the lawyers. They will have time for you. Or join us on our legal programs on Thursday between 9 and 10 a.m., Friday between 9:30 and 11 a.m., and on Saturday between 4 and 6 p.m. for the community and the law. I also want to remind you that for the topic we've discussed, you want to write your English language and, of course, the Life in the UK test, you can consult and contact KT Ed Educational Consult, and it will help you. Just pick up these numbers and get on with it. It's 07512 644041, 07512 644041, or 07596 620154, 07596 620154. Now, I'm taking a quick turnaround. I'm going to put the question on the screen, the scenario I want you to look at. And that comes along with, or goes along the lines of our nugget we put out earlier this week. And the question is this. Mina Mipiasem and her 8-year-old were living in a very appalling condition in a dilapidated apartment provided to them by a friend. Mina and her child had made a private life and parent root application, which was still outstanding. At the time of the application, they had no lawful residence and were therefore not entitled to public funds. Can Mina ask the local authority for support? Mina Mipiasem and her 8-year-old were living in very appalling conditions in a dilapidated apartment provided to them by a friend. Mina and her child, had made a private life and parent root application, which was still outstanding. At the time of the application, they had no lawful residence and were therefore not entitled to public funds. Can Mina ask the local authority for support? Number 1 says no, she's illegal. Number 2 says no, she does not have recourse to public funds. And number 3 sounds very positive. Yes, because her child is a child in need. Which of these 3 can Mina ask for? 1, 2, or 3? Come back to me with your answers on the platform, text, WhatsApp, after this short break.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Okay, let's hear what you have. Now, let's get a question again. Minna Mipiasem and her 8-year-old were living in very appalling conditions in a dilapidated apartment provided them by a friend. Minna and her child had made private life and parent root application, which was still outstanding. At the time of the application, they had no lawful residence and were therefore not entitled to public funds. Can Minna ask the local authority to support? No, she's illegal. No, she does not have recourse to public funds. Yes, because her child is a child in need. What answers do we have? Let's see. Antobam says number 3, yes, because a child is a child in need. Okay, let's get the next answer. Bless Lewis, number 3. Okay, next we have Ananaya, number 3. Another one from Prince Bafo Ajimai, number 2. Number 2 says no, she doesn't have recourse to public funds. Who else? Ruth Atia, number 3. Yes, because her child is a child in need. Next one, Reiki Eboche. Yes, because a child is a child in need, and also the child can maybe qualify for indefinite leave to remain since the child is 8 years old. Oh wow! Keep that. We'll come back to you when Antoinette is helping us and find out if Ricky's assertion can hold. Okay, now because of time, let me go to Uncle Ben for the explanation and the answer.
Yes, so we know that Section 17 puts a duty on the local authority to promote and encourage the health of children in their locality and help and promote and also ensure that a child in need is offered both accommodation and support. The very basic thing to do is to do an assessment. And once the assessment is done and it's determined that a person is a child in need, then they will have to offer the support. Minna Mpasem and her 8-year-old, obviously 8 years is a child. They have made an application. So although they are here illegally, there's an application pending because the council usually would like you to have an application pending. They are here unlawfully and therefore are not entitled to public funds. But in this case, it's a positive duty on the council or the local authority. And because they are living within the local authority, there's a duty for that needs assessment to be done. And in this case, because of the appalling condition, because promoting health and welfare includes living in a sound environment, that means that they will qualify. And the answer will therefore be number 3.
Well, need I say more? Mina Mipiasem, I think when you go into the fancy language, the Akan language, so to speak, it says Mina invites trouble to herself. well, and her child do not have adequate accommodation and do not have means of securing adequate accommodation, as Uncle Ben has explained. They do not have enough money to meet basic living needs. So if a child or vulnerable person is destitute, this is likely to constitute a breach of Article 3 of the ECHR. So the case Limbola versus Secretary of State for Home Department outlines these ones, and the answer is number 3. Can we go back to the question and to the answer that says number 3 says what? Yes, because a child is a child in need. Ladies and gentlemen, this is where I want to draw the curtain, but tradition is tradition. Let me go back to Uncle Ben. He will give us a brief summary of what he's taking us through. And I know the consensus is out there in the public. We need him back. Uncle Ben, over to you.
Yeah, so today we've looked at from zero to shiro or hero. And means that, from a child, obviously with nothing, to potentially a child with British citizenship indefinite leave, or long limited leave, or short limited leave. The law allows your child to become a British citizen if they were born here and have lived the first 10 years of their life in the UK. The law also allows your child to qualify for indefinite leave if they haven't lived here for 10 years, but were born here and have lived here for 7 years. The law also qualifies your child who is a young adult in between the ages of 18 and 25 and have lived here half of their life to qualify for either a long 60-month limited leave or a short 2.5 on the route to 5 years to settlement. Once they've spent 5 years on this route, they will qualify for indefinite leave, which used to be a concession and is now being captured by Appendix PL, which is private life. In addition, there are circumstances where people who have not lived here for 20 years can qualify for indefinite leave. But the threshold is very high. The threshold is that if somebody is an adult and have not lived here for half of their life, or are over 25 and have not lived here for 20 years, then if they can show that although they have not lived here for 20 years, but there are very significant obstacles to their integration in the country to which they are being asked to go and live, then they may qualify for leave to remain in the UK. Please, the word significant, it's not only significant, it's very significant obstacle. There's a case law of Parvin. There's a case law of La. Both cases put emphasis on the durability of the person's residence, but also you need to show that factually your circumstance is such that you cannot be integrated into your country of birth or where you've lived before you came to the UK. So it's a very difficult application to make. It's not impossible. There's a case law which clearly says that somebody who has issues with a country of nationality will qualify. This is not asylum I'm referring to. I'm referring to private life under PL, Appendix PL. So it's possible, but the requirements are very, very significant. The word and the operative word is very significant obstacles to integration in your country. And therefore, although it's possible, there are limitations. I hope this is helpful to someone, and God willing, we will see you again next week.
Obviously, very helpful to everybody that's been part of this discussion. I know you have most of your questions not answered, but we will be looking at that in subsequent programs, so don't worry at all. During the week, we'll have the senior partner come on board and help us answer some of these questions. So keep them coming through. Thank you so very much for sticking around, and let us all together say thank you to Uncle Ben, our senior partner, for spending time with us and sharing knowledge and experience with us. And to BWF Solicitors, we say thank you so very much for your kind sponsorship and also allowing us to operate under your auspices. To Lawyer Eunice, Lawyer Charles, and all the other young and learning lawyers here in the BWF Solicitors family, we say well done, kudos to you all, and keep doing what you're doing. To Cynthia, Sandra, the Lord Chancellor, and everybody at BWF Solicitors, we say thank you so very much for your support, research, and admin. To Sheila Ankara for the work you do all throughout the week, Padma Dodo for the aesthetics and designs, and to my studio producer, Professor Ade, for taking us through another wonderful edition. My name is Oreku Fimpon. Have the very best of the rest of the day. Have a good week, and we'll meet again, same time next week. Good evening.